But when talking about the issue of transcription that you mentioned, it's an issue that, of course, has been very close to my heart, but it's also something that's met with some resistance. And that's probably where we segue into the next session, where if I could kindly invite Dr. Matt Secomb, Mr. Jayant Mehta, Ms Kim Rooney to maybe put their videos on and come on. We would love to hear your views on a topic which, for a number of Indian lawyers specifically, is not very straightforward, because it's not a practice that we are used to. And for those of us, who don't know the debate, very quickly setting the context. At least traditionally in India, the way evidence recording is done is that you have a lawyer, they ask a question, there's a stenographer in the room. The stenographer has a computer, they have a projector which is projected onto a screen, and whenever a question is asked, the stenographer types it up, projects it onto the screen. Any corrections to the question are made, the witness answers the question. Not often is the answer taken exactly the way it is said. One, because of the limitations of speed of typing, and second, because sometimes the arbitrators paraphrase it or modify it or whatever. So there's some changes that are made, but it gets up on the screen. And once that is done, we move on. So the speed of questioning and answering is a little slower than it would be if it was just a conversation. There are advantages and disadvantages to it. But this debate will focus on looking at the two sides of the equation and seeing, is there really one right answer? Or is that really something that will depend from situation to situation? And to debate on these, I have three very eminent speakers. So Dr. Matt Secomb is a partner at White & Case based in Singapore. He's both a counsel and arbitrator who has done obviously hearings with transcription, but because he does a fair amount of India-related work as well, he's also had experience with this stenographer system of evidence taking. So he'll be speaking in favor of transcription and how that's maybe a better offering. And on the other side, I have Mr. Jayant Mehta, a senior advocate, a very eminent senior advocate in Delhi, who, of course, has done both again. He's been, in fact, an arbitrator where I understand CORD's transcription services were used, CORD being the predecessor of Terrace, and the transcription services were used. So he's used that even within our own knowledge, and I'm sure a lot more hearings beyond. And of course, he's used the Indian system of how evidence collection happens. So people, both practitioners who've done experience systems, talking on both sides of the equation. We then have Kim, who sits as an arbitrator in a number of disputes, and she'll again try and wear that arbitrator hat, try and evaluate the two arguments that are made before her, and present her views on this question. But with that brief introduction, I'll hand it over to the panelists. So maybe, Matt, you can take it on from here.
Okay, thank you, Vikas, and Honorable Judge Rooney, Senior Advocate Mehta, and ladies and gentlemen. Thank you for taking the time this Saturday afternoon to attend this event and to listen to this debate, because I think this topic is important. And I hope to convince you in the few minutes that I have to speak that even the most basic student of life, when they really think about it, would reach the conclusion that word-for-word transcription is superior to kind of a partial synthesization of evidence using a stenographer. Now, I loved my high school years. I went to a country high school, actually, in Western Victoria, where I'm from in Australia. And it wasn't a fancy school. It was, kind of basic. But the teachers were earnest and worthwhile, and quite often young. And they didn't try to teach us anything too fancy. To the contrary, they tried to teach us just the basics. And the subjects that I liked most at high school were English, history, and economics. And when I think about this particular topic, I think that if you think about what I learned in high school, you will reach the conclusion that word-for-word transcription is better than stenography. Now, taking first English. Now, English is a fantastic language, and it's a fantastic language to play with. If you study Shakespeare at all, you'll see that he plays with words like kind of like marionettes. He uses humor, politics, history, even some kind of cheeky, almost sexy, sometimes double meanings in his words. And what makes English a particularly fun language is its broad vocabulary. You have lots of different words, often with similar or subtly different meanings. Now, this brings me to lawyers, because what we're talking about here is obviously lawyers applying their art. Now, one of the skills of an advocate is not just the question that they ask, but the precise wording that they use in the moment of truth when they ask a question. Now, Indian lawyers, of course, and judges are famous for their broad and colorful vocabulary worldwide, particularly in the common law world. And, you get, for example, I was looking at a high court judgment in preparation for today. And, the passage I thought was fascinating. It was, the passage goes, "For facilitating its consummation through the learned executing court, stood enjoined to pronounce an appropriate order. Contrarily, it by relegating the impact of the aforesaid germane factum probandum." And it goes on. Now, this is wonderfully colorful language, perhaps difficult to understand, but it is a lawyer applying their art. Now, transcription captures the language. It captures the language of the hearing for all of its beauty, also for its imperfections, for its nuances, perhaps for its terrors. And it captures the beautiful language that lawyers use, perhaps the stuttering language that witnesses uses, and of course, it captures the questions and the pearls of wisdom that judges and arbitrators can bestow upon the parties. Now, by contrast, using the transcription method of stenographers, what you end up with is a partial synthesization of what happens, and all of the lawyer's beautiful words are kind of spilled on the floor and wasted, and what you're left is just a kind of pale synthesization of them. Now, I also liked history, and of course history is interesting because of what you can learn about the present from the past. But when you study history, another thing you study is the importance of how history is recorded. And to take one cliched example, it's the old adage that winners write the history. And so if you take, as an example, the Second World War, if you look at Western European representations of the Second World War, they will tell you that the tipping point was the D-Day landings in Normandy and how these heroic Americans and these stoic English kind of changed the war. But in fact, if you look at it objectively, it was probably more likely that it was the Russians on the Eastern Front and how they fought so fiercely for such a long time that really made a difference. Now, of course, a lot of Western recording of the Second World War also brushes out, the efforts of things such as, Indian soldiers, particularly in places such as North Africa. Now, this brings us, because what is the most accurate way to find history? And of course, that is primary sources. Now, if you want to know what happened at a hearing, the primary sources is what was actually said, and transcription records accurately, for better or for worse, what was actually said at the hearing. Now, by contrast, using a stenographer-led process, you had the classic problem of filtering history, because what the witness was actually said was filtered not through one person, not two people, not by three, but 4 people. It was filtered through what the stenographer chose to write down. Often, the questioning lawyer has a say in kind of changing the answer. And then, of course, the judge can step in sometimes in the aid of clarifying the question, can actually change what that was testified to. And then, of course, finally, even the witness themselves sometimes they'll say the truth off the cuff, but then regret it because they realize it's bad for their case, and they'll turn around and try to change history. Now, this is important because of the nature of arbitration, because of course, afterwards, the arbitrators have to draft the award. And having an accurate transcription of the whole process can be important in allowing the arbitrators to remember the testimony. And of course, arbitrators' concentration wavers. It's very difficult to keep the same high level of concentration for such a long time, and transcription helps with that. And of course, many arbitrators are quite old, often 70, 80, or sometimes even older. And what do old people do? Especially after lunch, of course, they take a nap sometimes. Now, transcription can be very helpful with that, because even if they do doze off, then you can actually go back to the transcript and explain to them exactly what was testified to, rather than that critical testimony being lost in this kind of fog of unrecorded history. Now, finally, as I said, I also liked economics. And of course, you learn basic economics in high school, such as, the price of a product is determined by supply and demand. Now, for clients, the primary price, of course, of any legal proceedings is the lawyers. That's the primary cost, as we know. Now, in India, if you take an example, there are a lot of lawyers, and so you can get some lawyers for quite cheap, but equally, there's only a limited number of these kind of precious senior advocates, such as my friend, Mr. Mehta, who we'll hear from briefly, and they charge quite a pretty penny for their work in cross-examining witnesses in arbitration. I understand that it can be, 30, 40 lakhs a day, huge amount. Now, reliable sources tell me that collecting evidence through, transcription is perhaps 3 or 4 times faster than using a stenographer. So if you're paying that amount per day for your senior advocate, you're saving a huge amount of money if the taking of evidence can be more efficient. So what that tells you is economics also favors transcription over stenography. So in conclusion, I would put it to this house that even a basic student of life, when you really think about it, would reach the conclusion that word-for-word transcription is, in fact, not only better, but vastly superior to kind of the stilted, partial recording of evidence through a stenographer. And with that, I very much look forward to what my learned friend, Senior Advocate Mehta, has to say.
Good evening, Judge Rooney. Hi, Matt. Good afternoon or good evening, as the case may be, to everyone. The motion, which is that transcription is better than stenographer-led recording of evidence, in my humble view, is too general and perhaps misses the woods for the trees. To my mind, it mirrors a one-size-fits-all approach, which I am not sure whether it's suitable for any legal proceeding, because every case is different. Now, we all know that transcription records every word that a witness utters or the counsel utters, but therein also lies its folly. It doesn't allow either of them to structure their thoughts, perhaps allowing the counsel to steal a march over the witness, because the counsel would be familiar with the system, but the witness may not be. And to my mind, the ultimate reason for recording of evidence is to ascertain the truth. Unless you allow the witness to structure their thoughts and to put it in the best way that they can, what you would be seeing in a transcript are unstructured rumblings of the witness or even the counsel. And what Matt referred to as parties jumping in, that is, the counsels jumping in or the judge jumping in, I ask myself, does transcription disallow that jumping in? It doesn't. You still can, and all of it will be recorded. So, really speaking, transcription is no answer to anyone jumping in, either to assist or clarify a question or an answer. But what stenographer-led evidence allows, at least in my experience so far, is a better structuring of the answer. Because ultimately, the witness is the star of the show. The judge, the counsels are there to hear what the witness has to say, and not hurry the witness into giving multiple answers to the same question for either not having followed the question fully or having only remembered a part of the question. Now, why do I say that? I'll give you an example. I recently concluded an ICC arbitration where the witness was an engineer. He has never been through cross-examination, and the witness was most comfortable in his native language, which was Marathi. He could speak English, but not so well. That was not his first language or mother tongue. Now, he was being cross-examined by a QC. So you don't just have two people playing out. You also have different languages in play, different intonations, and which may lead, and it did in that cross-examination, to a situation where the witness was not able to completely follow the question. Now, how would this be different? I ask myself, in a stenographer-led recording of evidence. So you would have the question being put by the counsel. It would be typed. It would be shown on the screen. So the witness has an opportunity to look at the question, to understand it, and then to structure his thoughts and give an answer. Now, that, according to me, is the aspect which is most important in recording of evidence. We must know what the witness wants to say in answer to a question. There is a second aspect where I differ from my good friend Matt, and which is that we can't confuse speed with accuracy. I am sure the books that Matt happened to read in the 3 subjects that he enjoyed would also be paraphrased. And I'm sure the teacher who taught Matt would have further paraphrased them and not read every word of every chapter of that book. So paraphrasing by itself is not bad. But paraphrasing that tends to interfere with the accuracy either of the question or the answer, and whatever be the setting, it could be transcription, it could be stenographer-led evidence. That paraphrasing is bad. But that's not an attribute of stenographer-led evidence. That's an attribute independent of it. So you really can't be blaming stenographer-led evidence to say, well, that allows paraphrasing of inputs or outputs. Then there is a third aspect. The third aspect, in my humble view, is equally important. I'm sure you would have seen in your respective professional lives, witnesses differ. Each one of them is not as articulate as the other. Some of them are very articulate, some of them are not so articulate. But can the system of recording of evidence be linear for both of them? It can't be. It must allow a not so inarticulate witness to structure his thoughts and give his answer. Of course, it can be said that nothing prohibits a witness to wait, structure his thoughts, and then give an answer when it is being transcribed. But we all know that transcription at least plays a very, very important role subconsciously, where the witness is under, I would not, for want of a better word, I would say some kind of a subconscious mental pressure to answer quickly, because all eyes are on him and the stenographer or the transcriber is raring to go. And I don't think that subserves the purpose of recording of evidence. Fourth, the transcription puts a not so articulate witness at the risk of being misunderstood, to be a witness who was changing answers to a question while developing his thoughts. The way in which a transcription would read is that the witness is saying one thing and then saying another and then developing into a third. Now, all of this could be quite natural, unintended, and certainly not an improvement of an answer. But that's how the transcript would read. That witness said, ooh, yes. Then he said, maybe, allow me to explain. And the judge may feel, well, I find this witness is not so reliable. Versus the stenographer-led evidence where the witness has the question in front. The judge says, Mr. Witness, think over, give your answer. If you're not so articulate, tell me, I will put it on the screen as your answer, read it. If you are happy with it, then we go to the next question. Fifth, I find from my experience that there is a greater involvement of the arbitral tribunal in a stenographer-led evidence than there is in transcription. Particularly when you have witnesses who are not so articulate or not so experienced in that system. In a transcription, even if the judge or the arbitral tribunal misses out for reasons that Matt explained of an afternoon nap, subconsciously they know there is something they can always go back to. But in a stenographer-led evidence, they better not go off to sleep. Sixth, I haven't come across a single arbitrator, me included, or a counsel who reads the entire transcript from start to finish. What do? Control A, Control F. We search. Don't we? And that's the truth. And I'm not saying that transcription as a method is bad, but you can't have one size fits all approach. You can have transcription in situations which warrant, require, and make it more practicable. But you cannot rule out stenographer-led evidence by saying, well, it's transcription and nothing else. Seventh, there is no escaping a stenographer. And since I am gunning for the stenographers, I'm sure we've all heard Vikas say that at the end of the day, the stenographers sit to correct and ensure that the transcript is absolutely accurate. So there is no escaping them at all. And lastly, I would say, Matt said, well, the counsels, and possibly I think he had a wrong impression of me, that he included me in them, charge a bomb for conducting a trial. There is no doubt about that. But that's no answer to say, well, I will prefer speed over accuracy of the evidence because I have to pay less to the counsel. So those were my points, and I hope the House resolves that the motion be defeated. Thank you.
Thank you. So perhaps I might just say a brief word in rebuttal to that very eloquent defense of stenography. And as there was some wonderful points made. And I'd just say one thing, particularly about the beginning of the presentation. We heard a lot of this kind of David and Goliath problem. That the problem is you have this poor, innocent witness and this kind of mean lawyer who's badgering them. And I'd say two things about that. One is that I think it's a bit naive because, I'll let you in a little secret, some witnesses don't tell the truth. And obviously one of the key purposes of the cross-examination process is to allow the lawyer to legitimately challenge the witness and to kind of use their skills to ultimately, kind of unmask a lying witness. And I think to some degree that's more easily done, and if the advocate has a more free hand in the way that they pose the questions. The second thing, which is related, perhaps more self-interested, is that I think, Jayant, maybe you're going to put us out of business, because one of our skills as advocates is actually beating up on witnesses. So, in a sense, we want to be given the opportunity to do that. But as I say, that was a wonderful expression of the arguments for stenography. I don't want to put stenographers out of a job. I agree that they'll always be around. But I still think that on balance, I think word-for-word transcription is a better approach.
Judge, can I take a minute to answer? Now, Matt, point taken. My point was never that you must do away with transcription. My point was that you can't have one size fits all approach. So you can't have only transcription or only stenographer-led evidence approach. You must have a hybrid. Number two, it is not, again, my point that the cross-examiner should be curtailed in any manner. But none of the two systems curtail the cross-examiner, neither the stenographer-led evidence nor the transcription. Number three, while it is a lawyer's skill to lead up the witness, I feel the most important and a non-negotiable aspect of recording of evidence is that the truth must come out, not through the leading of the witness, but what the witness has to tell the tribunal. Yes, you are quite right. We have all seen witnesses who are either too intelligent or quite experienced in misleading. And therefore I said, you could have a transcription for them. But to say as a general rule that transcription is better than stenographer-led evidence, I would say is too general and misses the woods for the trees. That's all. Thank you.
Well, may I thank very much both counsel for their eloquent, erudite, thoughtful, thought-provoking and entertaining presentations. I think the presentations or addresses of each of you have demonstrated the range of issues that can be generated by what looks like a very simple question or motion that transcription is better than stenographer-led recording of evidence. And among the issues that I found most interesting that were raised were, is it, as Matt Secomb submitted, the 100% record of all words said is necessary for the fair hearing? Or is it that the evidence of a witness should be distilled so that the truth, as they wish to present it, and that's what I hear Mr. Mehta saying, is what the objective is of taking the transcript of evidence, and the point that was made about whether or not the words should be added for the case to this motion were adding to that. So as I come back to your presentations, have illustrated the complexity and also gone to that question of what is arbitration about? Is it about finding the truth? And if so, what is the truth? Or is it about dealing with the case as presented by each party? So may I just say that at this point, I think both counsel were very compelling, and I'd just like to add a few comments, perhaps coming back to earth from the profound issues that were raised by counsel. But I should add one more point. I think it also demonstrated once again the cultural differences that can arise, the legal cultural differences in terms of approach to even taking evidence and what is required of evidence for an arbitrator or a tribunal to make a decision. So the few points that I wish to make were to say that in my experience in international arbitration, there's been a hybrid approach, but certainly the emphasis has been on 100% accurate transcript, but with human engagement in that the stenographers still play a very important role. But that's from traditions where parties have agreed to use a service to capture 100% and then for the lawyers to deconstruct as they go along in other ways. Among the issues that I suggest are being raised by use of technology, and very eloquent speakers have touched on this, are whatever form of transcription is used, whether it's technology generated or by the stenographer, there is the objective of achieving accuracy, although what is regarded as accurate today, we've heard, may be formulated rather differently. But using technology can give rise even more to confidentiality, the evidence being confidential. For example, arbitration is generally regarded as a confidential process, although that is being eroded in some respects. And to what extent does technology impact on that? Questions of cybersecurity, which the earlier panel talked about. The commercial use of data, because one of the things we're seeing, and I know this is moving a little bit away from what our speakers were addressing or our counsel were addressing today, but as services are providing these transcript services, as they're going beyond the stenographer, the human being in a particular hearing room, to a professional service, but one that is providing these services as part of its commercial business, and it's using the data it's getting from these transcripts for its broader business functions. There's already some questions coming up about that. Cost, counsel had quite different approaches to how relevant is cost, how much does it matter, but it does seem that certainly from my observation, there are occasions where the cost of transcription, where you're using humans plus technology, is becoming very high. Put aside counsel, just look at the cost of the service, and technology can lead to a reduction in that. And before I get to my last point, may I just say I thought the point that was made by Mr. Mehta about whether or not engagement by tribunal is enhanced if there's a stenographer was a very interesting point, although I thought perhaps Dr. Secomb's comment about arbitrators nodding off was a cheap blow, because I think these days it's totally unacceptable for arbitrators to nod off, and in fact parties have challenged awards on that very ground. But anyway, that is part of the entertaining nature of this debate. But the last point I wanted to come to was in terms of the future, and the last panel talked about this, and Vikas has mentioned it, that automated decision making is in the pipeline, that, as we know, there are some institutions already exploring tools to assist arbitrators, or indeed to take the place of arbitrators. And one of the questions that your address made me think about, your addresses, is how will transcription by digital processes impact or work with that kind of automated decision making? Anyway, I know that's going a long way away from here, but coming back, thank you very much. That was the most interesting and thought-provoking debate. I thank you.
And thank you all. And I completely agree with what Kim said. It was extremely engaging and very, very valid points. And and I guess there will always be situations where maybe one situation is better than the other. But I guess the audience now is at least informed of what the pros and cons of each are, and they can make an educated decision on it. Just one point I wanted to make before I sign off is on the issue of costs. And that's actually been a very significant issue for people to adopt transcription. Historically, it's been extremely high. And that's primarily because the people who do the transcription, and I learned it very recently, they undergo at least 2 years of training on a machine that's not a keyboard, it's a phonetic keyboard. And that is what leads them to the high levels of accuracy that they have, which is about 200 words per minute, which is mind-boggling. And that's why it's expensive. But with technology coming in and making it more accessible and affordable, for instance, the kind of solutions that Teres offers, it may become something that people can consider more broadly than they have considered historically. So if at all there are situations that people think transcription is better, maybe cost will hopefully not be as much of an issue as it has been previously. But maybe with that note, I would again like to thank all of the panelists and Kim, Ms. Mehta, and Matt for your very eloquent statements and for making time out for this. But that is all we have for the evening. I thank all of the participants for being here with us. If there's any further questions, I'd request you to maybe just email it to us and we'll try and get back to you, because I think we're running a little over schedule, so we may not have time for questions. But that's all from us for the moment. Thank you, everyone, and hope you have a pleasant evening and enjoy your weekend. Thank you.